I pray for small.
One second. Yes. Huh?
I pray for small accommodation, my lord. My lord, I have 4 items in footnote 1, my lord.
Wait, I cannot hear you. You just use the mic properly. Yes. Yes.
My lord, I have pray for small accommodation, my lord. I have 4 matter in item in footnote 1, my lord. The completion of that matter, my lord, is I'll attend this
Okay.
item.
You finish those matters there, then come.
Yes, my lord. Okay. File.
Yes.
May this your lordship, may I seek your indulgence in mentioning item number 3 of part 2?
3 of part 2. Fixed today.
Yes, your lordship.
1 second. Tuesday. Okay. 3 is fixed for today. Yes. What happened?
Your lordship, my senior Bilaram Enga is sick, and with the consent of other parties, can this matter be kindly taken up on 3rd of August?
3rd of August. You
Yes,
mean
Your Lordship.
Mr. B. Lalram Enga is not well?
Sick.
Okay. Learned 3 में लिखो. Learned counsel for Miss
Laram Adirentle.
Learned counsel appearing for the learned amicus curiae submits that the learned amicus curiae is not well and as such has prayed for some time. Prayer is allowed. List this matter on 3rd of August.
Thank you, your lordship. I seek your lordship indulgence on mentioning item 4 of part 2 hearing list. My lord, my senior, he cannot appear today due to health issues and he's at the hospital. And with the consent of the other parties, if this matter may be listed on 4th of August.
Okay. Right. Number 4. The learned counsel appearing for the your name, please.
Banal Sandame.
You're there in the record on board. Miss Valnan Chandami, learned counsel appearing for the appellant submits that the conducting counsel has some medical issues and has as such prayed for some time. Prayer is allowed. List this matter on, when did you want?
4th of August.
And list this matter on 4th of August as prayed for.
Much obliged.
Yes, Mr. Victor, didn't see you for these days.
I was out of station, your lordship.
Yes.
May I make a mention in respect of item number 19 of hearing list?
Hearing. 19.
Yes, your lordship.
Yes.
This I have spoke with the senior counsel for respondents. If this may be taken up on the week hearing list on the week commencing from 3rd of August.
Acha. Okay. Mr. Victor L. Ralte, learned counsel appearing for the petitioner, submits that the matter be taken up on a later date. Prayer is allowed. List this matter when?
In the
List
week
this matter.
in the week commencing from
List
3rd
this
of August.
matter, in the week commencing from the 3rd of August 2026 by the registry.
And item number 7, your lordship. Hearing list, item number 7. This may also be taken up on fixed on 3rd of August.
Okay. Mr. Victor L. Ralte, learned counsel for the petitioner, submits that the matter be taken up on 3rd of August 2026. Prayer is allowed. List this matter accordingly.
Much obliged.
Daily list for admission item number 1.
Mr. Victor, you are there?
For the state respondents. I'm still awaiting instructions on behalf of the DC Longklai as well as the Forest Department. If I may be granted some more time, my lord.
Apart from that, the impleading application is not filed.
Not yet, because the forest.
Yes,
may be-
Mr. Victor?
According to the petitioners, my lord, the impleadment is not necessary, but it's up to
But
the...
then why? It is reflected in the office note.
My lord, at one point of time, the state respondents are proposing to implead the forest department. But what my learned friend is submitting is that the forest department has not yet confirmed whether they would like to implead or not. So, besides that, my lord,
It
we
is
are
not
waiting
for them to decide. It is for you to decide whether forest department.
According to the
is a-
petitioner, my lord, it is not required.
Acha. He is not a necessary party then.
Yes, my lord.
You have not-
There was an award. There was an award. That award has already been approved. No one challenged the award, so it has to go on.
So, forest department, you have not claimed relief against forest department?
No, my lord.
Okay. But then on the last occasion, she has not received from the forest department and also she pays for and to apprise you for the compensation amount. Okay, compensation amount, this is for compensation.
Yes, Your Lordship.
And compensation is to be paid by whom?
By the Ministry of Road Transport and Highways.
Transport and Highways. So you are seeking instructions from whom?
From both the forest department as well as the DC Longkai, because in the last order, my lord, the DC Longkai has to make, has to give reasons as to why the compensation amount has suddenly risen to a certain amount.
What?
The compensation amount, my
Huh.
lord, in draft award 2022 has risen to a huge amount in another draft award 1 of 2026. In
So
the
whatever it
subsequent
is,
award.
Miss Zairang Sangpo, you are appearing for?
I am here from Ministry of Road Transport.
Transport and Transport Department. Okay, have you filed your affidavit or what?
My lord.
Not required.
At this stage, my lord, the state government is requested to obtain instruction as to whether the award already made in the year 2022 has been increasing huge amount in the year 2026. Let them explain first, my lord.
Okay, you bring the instructions then. Last occasion also you took 10.
Yes, ma'am. I'll have to seek some more time, my lord, because I am still awaiting instructions from both,
Forest and Transport.
not transport, forest as well as the DC Longkai.
DC Longclay.
Yes, ma'am.
Okay, heard Mr. Vikram L. Rajay, learned counsel for the petitioner. Also heard Ms. Linda L. Falber, learned additional AG for the state respondent, and Ms. Zairang Sangpui, learned counsel for
Respondent number
8.
respond number
8.
8. Respond number 8. Ms. Linda M. Falber, learned additional AG submits that although she had taken time on the earlier occasion to get the instructions from the forest department, but she is yet to receive the same. She as such prays for some more time to get the instruction from both the forest department as well as the office of the deputy commissioner Longclay. Prayer is allowed. List this matter. After
6th of August, if possible, my lord.
list this matter on 6th of August for further consideration.
Highly obliged.
Obliged.
Item number 2.
Yes, 2 is a first appeal.
My lord, the leading counsel, Mr. Laram Sang Haka, has personal difficulties and may this matter be listed again this coming Thursday or Friday?
This Thursday, Friday. Today
Or
is
Thursday
Tuesday.
or Friday? Yes, my lord.
Acha, this is a matter which I heard. The condemnation was allowed by the Supreme Court.
Yes, my lord.
And as such, the RFA also stood restored.
Yes, my lord.
So today is for admission of
Yes, my
RFA. And have you prayed for some interim or not?
My lord, if I may make one small submission, in the main RFA, notice has not been issued.
No, yes.
if notice may be-
I have
formal notice may
directed
be
for
issued.
listing of the matter
Yes.
in admission. So we will issue notice, but then she wants time, she said.
My lord, then 20 January 2025 notice was completed.
No, notice is not issued in the RFA.
Yes.
RFA was dismissed
That was
because
in-
of
Okay.
That
Oh,
was
sorry,
in
my
respect
lord.
of the condemnation application.
In respect of the main petition.
Okay, day after tomorrow,
Yes, my lord.
Thursday.
My lord, I have personal difficulty. I will be out of station on Thursday.
Okay. Friday it will not be very possible to take up.
My lord.
So we will fix it on next Monday.
My lord.
Yes, my lord.
Okay. As heard Miss
Jacinta Zotanmoye.
as Jacinta Jothangmoi.
Yes, my lord.
Yes. Heard Miss Jacinta Jothangmoi, learned counsel for the appellant, and Mr.
Tila Zakima, my lord.
T. Lal Zakima for the sole respondent. Ms. J. Jothang Maui submits that the matter be taken up on a later date as the conducting counsel has some personal difficulty to appear today. Prayer is allowed. List this matter on 27th of July 2026.
Much obliged.
Item number 3.
What is that?
Your Lordship may kindly refer to the order passed by this court on 29/6/26. Here, this Honorable Court has
They are
framed.
yet to file their response. Respondent number 1 and 2.
Yes, my Lord. My Lord, in my understanding, whether the response is necessary in the form of written objection or not, because this is with regard to substantial question of law that has been framed. And this Honorable Court will look into the evidence and the law which is needed in the present case.
Acha.
This is with respect to one important aspect, whether non-signing of the deposition form would render the evidence led by the claimant null and void. So that is one of the substantial question of law.
Only one.
No, there are three. There are three substantial question of law which was framed in the present matter, my Lord.
Yeah.
If your Lordship may kindly come to 29/6/26 order, I'll just read that. Whether non-signing of the deposition form by the appellant would render the evidence of the appellant recorded through audio or video mode by the Learned Commissioner, Employees Compensation Act 1923, is all void and nugatory. B. Whether the Learned Commissioner, Employees Compensation Act 1923 could have discarded the evidence of the appellant when its predecessor had, in acceptance thereof, appended signature in the deposition form. Whether the Learned Commissioner, Employees Compensation Act 1923 failed to take into account that strict rules of evidence does not apply in the present case, and whether the criteria for recording evidence under Section 25 of the Employees Compensation Act was complied or not. Now, in this case, the predecessor judge had already accepted the deposition, and the trial judge who had written the judgment did not accept that, my Lord. Whether that is correct or not has to be looked into, my Lord.
Acha.
Today, TCR has arrived, and I think the next course would be for hearing, my Lord.
So, okay, decide on a hearing date.
Yes, my Lord. No paper book would be required.
Otherwise, paper book is to be prepared.
No paper book would be required, my Lord.
Required.
There are three witnesses who deposed before the Learned Trial Court. I have annexed in the present petition, my Lord.
Acha. So, okay, when will you do the hearing? Otherwise, shall there be any more substantial questions?
No, I don't think so, my Lord.
Only these three.
Only these three.
And these three has been admitted by this court.
Yes, my Lord.
So, okay, agree on a hearing date.
My Lord, could it be on 28 if it's acceptable to by learned friend?
28th of this month,
Yes, my Lord.
July. Acha. Okay. Or can it be done today? You are ready, both the parties?
No, my Lord.
Why?
Leading counsels in respect of both the respondents, my Lord.
Respondent number 1 and 2.
Yes, in fact.
So, who is appearing? You are there?
Yes, I am appearing on behalf of my senior, who is the empaneled advocate for the insurance
Sandeep
company.
Chamaria.
No, Mr. Lafakoma. Correspondent number 1.
I'm Fakzola.
Lafakoma.
Lafakoma. Yes.
Okay.
He is the,
What happened today? He was
is
here.
the empaneled counsel for the insurance company. And my Lord, only he can appear in the hearing.
Okay, and what about respondent number 2?
Lord, I'm appearing on behalf of Mr. Sandeep Chamaria.
Okay. So he is not there today. He can appear online. But taking up hearing matter through online is a difficulty.
Yeah, that would be difficult, my Lord.
Better to have physical appearance. Okay. I heard Mr. C. Lalfak Zwala, learned counsel for the appellant, and Mr.
Bilal Zakima, man.
L. Zakima, Lal Zakima, learned counsel for respondent number 1, and Mr.
Mas Samdong Zelat.
For respondent number 2. It is noticed that the substantial questions of law in the instant case has been framed, and the learned counsel submits that no other substantial question is required for adjudication of the instant case. Matter as such is, full stop. Then it is also stated that affidavits on behalf of the respondents are not required in the present proceedings. And as such, it is submitted that the matter is ready for hearing. However, the learned counsel appearing for respondent number 1 submits that the conducting counsel has some personal difficulty in conducting the case today. Similar is the statement of learned counsel appearing for respondent number 2. As such, list this matter for hearing on, take a agreed 27 will be too early, I think, okay, 4th of August,
My lord,
4th of August 2026 for hearing.
obliged.
Item number 4.
Yes, criminal appeal.
May it please your lordship. Lordship, there is a criminal appeal against conviction. My lord, the order was passed by the learned sessions judge, NDPS Act, whereby the
On the
appellant's
last occasion, delay was condoned.
delay was condoned, your lordship.
Okay, now let us admit it, call for the records.
Yes, your lordship.
Okay, heard Mr.
A. Ghoshal on behalf
A.
of
Ghoshal,
yes, your-
learned counsel for the appellant, on behalf of Mr. M. Biswas.
M. Bishwas, your lord.
On behalf of Mr. M. Biswas. And Ms. Venishami, learned APP for the state. This is a criminal appeal filed under section 415
Yes, your lordship.
of 415 of BNSS 2023, challenging the judgment and order dated 15/7/2025. Oh, challenging the judgment, huh? Dated 15/7/2025 and sentencing order dated 16/7/2025, passed by the learned special judge NDPS Act, Aizawl Judicial District, Mizoram. In sessions case number 398/2023. Full stop. By the said judgment, the appellant, there is only one appellant,
Two appellants, your lordship.
or the appellants were convicted under section 21C and 20 within bracket small b, within bracket Roman small 2, and within bracket capital B, read with section 29(1) of the NDPS Act 1985, right?
Yes, sir.
NDPS Act 1985. Full stop. By the said judgment, after the said conviction, the appellant was heard on the sentence to be imposed, and a sentence of rigorous imprisonment for 10 years with a fine of rupees 1 lakh, and in default of fine, he was further sentenced to undergo. How did I start with the sentence? Heard on the sentence, and he was sentenced to undergo rigorous imprisonment for 10 years with a fine of rupees 1 lakh, and in default of the fine, he was further sentenced to undergo RI for another 10 months. Full stop. And the appeal is admitted. Call for the TCR. Any informant?
Yes,
No,
your lordship.
Huh?
The respondent number 2, your lordship.
Ms. Venishami appears for respondent number 1 as well as respondent number 2.
Yes.
And as such, no formal notice is required to be served. However, extra copies may be given to the learned counsel appearing for the state. List this matter and nothing else. Call for the records and admitted. List the matter on 12th of August. If the records are received by then paper book. 12th of August 2026.
Obliged, your lordship.
Item number 5.
May I please, your lordship? Yes. Lordship, notice is all completed and today I'm ready for hearing.
TCR is also not received.
Okay.
No, Emily Changte is appointed as the legal aid counsel.
Yes.
For respondent
Che.
3.
Yes.
And
Lordship,
what
I'm
about the
appearing on-
others?
Lordship, I'm appearing on behalf of Mrs. Emily L. Sangte. She had submitted her leave of absence.
Okay. She is on maternity leave, it seems. And for respondent number 3 only.
Yes, ma'am.
And what about other respondents? You?
Your Lordship, I'm standing on behalf of Mr. Benjamin Lalthamwana for respondent 1 and 2.
1 and 2. So 1, 2, and 3 are represented. There are 7 or 8 respondents. Yes? Okay. 7 and 8 state. So what about 4, 5, 6? Service is not complete.
Complete?
Complete.
Yes. If your Lordship permits,
So service upon 4 to 6 are complete.
yes,
So services are all complete.
yes,
Only TCR is not received.
yes. And with regard to the respondent number 3 also, my lord, she is on respondent number 3 is a pro forma respondent. We did not have any specific relief claim against him. So hearing will be possible if your Lordship permits.
But of course, subject to the receipt of the TCR.
Yes,
But without the TCR, paper book is prepared. Or
no
what?
paper is prepared.
Paper book is prepared without the TCR, Mr. Yes, additional AG will.
No, my lord. Not yet prepared, my lord. You have
What
to
is
call
this?
for
This
the
is a big-
TCR and prepare the paper book, my lord.
What is this? This is a big what? This is not paper book.
The RFA.
Okay, okay. Pages are being torn. Okay. Okay.
The thick one is the RFA, my lord.
Okay. Third, Mr. Yes, your name, please.
K. Kamthian Manga.
K. Kamthiang Manga, Learned
Yes.
Counsel for the appellant.
Yes.
And Mr. Your name? 1 and 2?
Ronald Choza.
And Joseph for respondent number 1 and 2. And Mr.
Stephen Lalbwas.
For appearing on behalf of Emily L. Changte, Learned Counsel for respondent number 3. And Mr. Lal, I forgot your name.
Samuel, my lord.
Samuel, yes.
Yes,
Mr. Samuel for respondent number 7 and 8, that is the government counsel. And it is also, and it is seen that the notice upon respondent number 4 to 6 is also complete, although there is no representation today. It is seen in the office note that the trial court records have not been received. As such, registry is directed to issue reminder for the same. List this matter again for further consideration on 6th of August. Okay, 6th of August.
Applied.
Item number 6.
Yes, this is jail appeal.
Yes,
What has to be done today?
and notice upon respondent number 2 is still awaited, Your Lordship.
Oh, a POCSO.
Yes, POCSO Act.
So when can you get the instruction? The officer in charge of Samphai police station, Samphai police station, but the service report is being awaited. As such, she states that the matter may be taken up on a later date, on which they should get the instructions from the concerned police officer. List this matter on 7th of August. Okay? August 20.
Applies.
Item number 7.
Your Lordship, my senior is on leg, and if the matter may be passed over for a while. My
For the
senior is
time
on
being.
leg.
Okay.
Item number 8.
My lord, we have received the paper book, so if this may be taken up for hearing in the usual course.
Paper book is prepared.
Yes, we have already received.
And the respondent side have also received, right?
Yes, madam.
Mr. Samuel, you are there for the
We've
matter?
received, my lord. For this
Yes. So, can it be done today or some other day?
Some other day, my lord. if it may be taken up in the usual hearing course, my lord.
Okay. There is some interim order here.
No, my lord. No.
My lord, that may be fixed, was it's pending long time.
Matter has been pending for long years, 2024. And if it is fixed for usual cause, then it will take long.
My lord, my lord.
Agree on a date for hearing? Heard Mr. Lal Zekima, learned counsel for the petitioners, and Mr. Samuel V. Changte, learned additional advocate general for respondent number
3 to 6, my lord.
3 to 6, and Mr.
A.K. Rokum for respondent 1.
Hukum for respondent number 1. What about 2?
2, there's a legal aid counsel, my lord.
He is not there today? Now, it is full stop. It is seen that a legal aid counsel has been appointed to defend the cause of respondent number 2. However, he is not present today when the matter is called up. It is further noticed that the paper book is prepared and is served to all the parties. As such, the case is ready for hearing. The learned counsels for all the parties have agreed for hearing of the matter on
13 August.
13th of August 2026. List accordingly.
Right, my lord.
Item number 9.
Yes, Miss Jacinta, what is to be done? So many IA here.
My lord, IA number 78, 80, 82, 84, 86, in respect of the respondent number 1, 2, 9, and 11.
Achha, what is this IAs about?
IA is regarding the substitution and continuation.
Substitution.
Yes, and continuation. This is continuation.
Acha, acha. What about the first IA? IA number 78?
78 is also same thing. In this present RFA, there are 77 persons who had already died before the instant suit was filed.
Acha.
Because
Before
of
the
that,
title suit, they expired.
yes, they
7
had
of them.
5.
5. Okay.
Because of that, I am filing the substitution application and condonation application.
In the condonation application.
Yes.
Okay. So, notices are served.
Notice has been served and ID card has not been returned for the respondent number 1, 6, 7, 8, and 10.
6, 7, 8, 10.
Yes, my lord.
These are all family members or what?
Yes, they are all siblings and they already demise and we are trying to serve their legal representative.
Okay. So, what is to be done today?
My lord,
Duly signed AD card for service of notice upon 1, 2, 9, and 11 has returned.
yes, my lord.
1, 2, 9, and 11.
For all the application 78, 80, 82, 84, 86.
78,
80, 82, 84, 86.
80, 84, 86.
Yes, my lord.
In those cases, what happened?
Because they are residing in Aizawl. And for 6, 7, 8, 10, they are residing in Silong. Because of that, ID card has not been returned.
Okay.
Let's wait for some time, my lord.
No, but I will go by one. First one, in respect of I-78, some of the respondents are yet to be served, right?
Yes, my lord.
Three, 4, 5, and 6, what happened?
3, 4, 5, and 6 are the government.
3, 4, 5.
3, 4, 5, yes, my lord.
3, 4, 5, Mr. Samuel, you are appearing?
Yes, my lord. For the state, my lord.
Huh. And 1, 2, 9, and 11 served.
Yes, my lord.
So rest what? 6, 7, 8, 10
6, 7, 8, 10.
are yet to be served.
Yes, already served, but ID card has not yet returned. And let's wait for
Notice is
some time.
taken, but no AD card. Okay, we will wait for some more time. The learner heard Miss Jacinta Jothang Maui, learned counsel for the applicant. Or the condonation application can be taken by this court without them.
It's up to your lordship. But
How
their
many
private
days delay?
respondents are there, madam.
78.
78 days delay.
78 condonation delay is
But there are no
11,000
representation on
is-
behalf of other respondents.
Yes, my lord.
Only you are there, other respondents are
No-
not represented.
Let notice be completed, my lord, at least, because they might want to file an objection, my lord.
That is also there. Okay, heard Mr. So-and-so, Jacinta so-and-so for the applicant, and Mr. Samuel L. Changte, V. Changte, right?
Yes, ma'am.
V. Changte for the additional AG for the state of Mizoram, who appears for respondent number 1, for respondent number 3, 4, and 5. It is seen in the office note that service of notice is complete on respondent number 1, 2, 9, and 11. However, the notice has not been served upon respondent number 6, 7, 8, and 10.
my lord, notice has been served, but ID card has not been returned.
Notice is served.
Yes, has served and ID card has not returned.
Acha, notice, however, although notice has been served upon respondent number 6, 8, and 10, as is reflected by the office note dated 18/5/2026, right? But the AD card has not returned in respect of the said respondents. As such, this court deems it fit to wait for some more time with regard to service of notice upon respondents. List this matter again on what date? 12th of August.
Yes, my lord.
12th of August 2026.
Obliged, madam.
And then in respect of item, then 77, IS 77.
77 is regarding the substitution.
There is no delay there.
Delay is there. 77 and 78 are the same matter. 77 is regarding the substitution and 78 is regarding the condonation.
There is no 78 here. 77, then 79. 80, 81.
79, 81, 83, 86 are the substitution application.
Acha, give me this second file. Second file. Here also there is some delay, right?
Substitution.
Oh, only substitution.
For substitution, there is a delay because of that I am filing the condonation application.
In item 77 for substitution, notices have not gone.
Not yet. Not yet gone.
No, this has
Not
come
yet
up for
gone.
the first time.
Yes, my lord.
Notices should go to the respondents, right? To
Yes.
the newly substituted. You are substituting whom? Respondent number 6.
Respondent number 6, my lord, yes.
So this Lalnun Puya has expired. And in his place, you want to substitute Lalrem Twangli.
Yes, my lord.
Okay, right. This is an application. Heard Miss Jacinta Jathang Mavi, Learned Counsel for the applicant. This is an application under Order 22, Rule 4 of the CPC, read with Section 151 of the CPC 1908 for substitution of respondent number 6. In RFA number 5 of 2026.
My lord, if this court may permit, may I serve a notice upon upon the IA number 77, 79, 81, 83, 86.
Okay, which one? 77?
79, 81, 83, 85.
All are for substitution.
Yes, my lord.
Okay, learned, okay, so in RFA so and so. Issue notice upon the respondents. The petitioner to take steps for service of notice upon the respondents by AD, by speed post with AD or by usual process. Okay, you take you take steps for all the respondents, 11 respondents.
Yes. Respondent 1, yes, my lord.
Okay, but, I mean, Mr. Samuel is not there. Miss Venishami are appearing for the state respondents.
Yes, your lordship.
Miss Venishami appears for respondent number 3, 4, 5. See the respondents? 3, 4, 5.
Yes, your lordship, 3 to 5.
3, 4, 5. And as such, no formal notice is required to be served on her, but extra copies may be given to her by the learned counsel appearing for the applicant within 2 days from today. Okay, list this matter after 2 weeks on a date to be fixed by the registry.
Yes, my lord.
This is 77. Acha, same is in respect of 79, 81, 83, 85.
Yes, my lord.
No, we'll have to see the respondents. In 80, you write I-80. So, AD service is complete upon respondent number 1 and 2.
1 and 2, 9 and 11 complete.
3, 4 and 5, which Venishami is appearing.
Yes.
6 to 11, AD card is not received. So, we will wait. Third, Miss Jacinta, right?
My lord, in respect of IA number 80 of 2026, AD card for respondent number 1, 2, 9 and 11 has been returned, and for respondent number 6, 7, 8 and 10, AD card has not returned.
No, but then in the office note it said duly signed AD card for service of notice. 1 and 2 has returned only. 1 and 2 only. 6 to 11 are yet to come. Heard Miss Jacinta Jotang Mawi, learned counsel for the applicant. The office note reflects that the service is complete upon respondent number 1 and 2. However, in respect of respondent number 6 to 11, the service is yet to be complete. Service is yet to complete. Ms. Venishami appears for respondent number 3 to 5. As such, no formal notice, extra copies. List this matter after 2 weeks on a date to be fixed by the registry.
Madam, regarding the IA number 70, 77, 81, 80,
Wait,
77, 79.
80 is over. Now 82.
81, in respect of IA number 81 of 2026.
81, where did 81 go? Acha, it is after this. Okay, 81. 81, what happened? This is for substitution?
My lord, someone be issued to the 11 respondent.
81 will be same as of 77, right? 79.
79.
Ki disilu se 79 disuno? 79 disutu. 79 ematu dilu se? 79 idea ne? 78 disu, that's what 77. That's what, 80 disu. Where is 79? Let's see, Courtmaster. 79, have I kept it here? 80. Oh, 79 there ne. 79, where did 79 go? Okay. 79, yes. 79 again for substitution.
79
is for substitution. 79 eke hobo. This is an application under the disu kunbata. Same, huh? application for substitution of respondent number 7, not 6. Earlier it was 6. Respondent number 7 in RFA number 5 of 2026. Issue notice. Petitioner to take steps for service of notice upon the respondents. Ms. Venishami, Learned State Council appears for respondent number 3, 4 and 5. In respect of respondent number 1 to 6 to 11, the petitioner is directed to take steps for service of notice by speed post with AD or by usual process. List this matter after 2 weeks on a date to be fixed by the registry. So 80 this, 81. 81 is also for substitution. So many people had died. 5 people you said, right?
5 people, they had already died prior to that.
Achha. This is for Apohi, this is an application likhiba for substitution of respondent number 9 in RFA 5 of 2026. Issue notice, petitioner to take steps for service of notice upon respondents. It will eke 3, 4, 5, Venishami, rest by speed post. 81 is done. 82 also same. No, 82 is different.
Respondent number 1, 2, 9 and 11 had received.
Achha, condonation
Etiquette
is there
has
in
been
every
returned.
application.
Yes, my lord.
What is the delay you said? How many days?
480,
480 something.
80, 81, 82,
Only 82.
5,014.
5,040 days delay.
14 days, yes.
5,014 days.
Yes.
After so many years you have come.
No, they supposed to substitute during the pendency of the suit, but they did not substitute.
Acha.
Because of that, I'm doing right now.
Okay. So there is a delay in substitution only.
Yes.
In filing the RFA, there is no delay.
No, no delay.
Acha. Okay. Acha, you write in 82, I-82, heard so-and-so itu diba, Venishami for state respondents. The office note reflects that AD card for service of notice upon respondent number 1 and 2 and 9 and 11 has returned. Ms. Venishami appears for respondent number 3 to 5. As far as service of notice upon respondent number 6, 7, 8 and 10, the same is awaited. Oh, no. 10, the AD card has not received and the same is awaited. List this matter after 2 weeks. Then 84.
83 and 84.
83, yes. 83, again for substitution, right? For respondent number 10.
No, someone to be issued to all the respondent. Someone notice.
Notice?
Yes.
Notices have not gone in this case.
Yes, not gone, and if permit may.
Yes. So you take notice for service of, you take steps for service of notice. Venishami for 3, 4 and 5. Same. Okay. To take steps. This is for substitution of respondent number 10. Then 84. 84 likha as a heri. So
Respondent number 1, 2, 9 and 11 etiquette has returned, and 6, 7, 8 and 10 has not yet returned.
Acha, same as the earlier one. Immutable likha I heard Miss so and so and so and so. But the office note reflects that AD card for service of notice upon respondent number 1 and 2, 1, 2, 9 and 11 has been received. Ms. Venishami appears for respondent number 3 to 5. As regards service of notice upon 6, 7, 8 and 10, AD card has not received back, and as such the service is awaited. List this matter after 2 weeks. 10, 86.
85, if permitted, may I take step for serving a notice to the respondents.
Acha, 85 is for substitution of respondent number 11. You had not filed all the applications together. Few notices have gone, few notices have
No,
gone.
I felt all together, but they direct me to serve a notice upon the IA number 78, 80, 82, 84, 86 only.
Okay, here it is the same thing. Application for substitution under so-and-so. This is substitution for respondent number 11. In RFA 5 of 26, issue notice, petitioner to take steps for service of notice upon the respondents. Ms. Venishami appears for respondent number 3 to 5 and as such no formal notice. However, extra copies. List this matter after 2 weeks. 86 sir, likha.
86, respondent number 1, 2,
Same.
9 and 11 has.
Why the other
Etiquette has
respondents could
returned.
not be served? Let us see on the next date, right? Etu eke hobo. Heard Miss Jacinta and Miss Venetiani learned the office note reflects that AD card for service of notice has been received from respondent number 1, 2, 9 and 11. However, the AD card with respect to respondents number 6, 7, 8 and 10 are yet to be received. As such, await for the service of notice on the said respondents. List this matter. Ms. Venishami is for respondent number 3 to 5. List this matter after 3 weeks, after 2 weeks on a date to be fixed by the registry. Okay. Then RFA, okay, let this be complete. Then we will go to the RFA.
Yes, my lord.
Okay. RFA likhe diba, list this matter after 2 weeks along with the interlocutory applications on a date to be fixed by the registry.
Supplementary list, item number 12.
Oh, what about 84, 85, 86 I did, right? Okay. Item number? Ten and 11, what happened? Oh, it's Medi's day. Okay. So 12, yes, Mr.
Yes,
Johnny?
Lordship, yes.
Yes.
Lordship, this is a criminal petition, and
But
in this
service is not complete. What happened?
notice is not complete, Lordship. Then office note indicates that the notice upon the sole respondent returned unserved due to insufficient address.
What is this matter about? Petition?
This is regarding, Lordship, I'm challenging the Zimanama order.
Oh,
So it was listed yesterday. So I was on leg yesterday.
huh.
So it was listed again today. Lordship.
So Jimma number, you are objecting to the Jimma given.
Lordship, before the Larnet trial court, I don't have any chance to to place my objection. So it was passed an ex parte. So that is one of the main grounds for coming before your this court, Lordship.
But what vehicles were given?
Lordship,
Vehicles were given.
yes, Lordship. This is regarding the transportation of the commercial quantity of heroin.
No, what custody was given? Vehicles.
Vehicle. There are two
You
vehicles.
want it back.
Lordship, yes, I want it back. And
See, Supreme Court has said vehicles and all should not be
I
kept
agree
for
with
long.
you, Lordship, but the problem is that the Larnet Tribunal failed to appreciate the claim made by the respondent because he is not the registered owner. It was registered in some other name. So what the Larnet Court has to do is he has to see whether the applicant was the actual owner or not. That has
Actual
to-
owner or insured in his name, or was it seized from him?
was not from him. It was seized from the two occupants, two vehicles involved. Lordship,
But in his absence, can I take it up?
I don't know.
Because it
Because
is
notice is not
order
complete,
is
yes.
in favor of him. If I reject your application, I can take it up. But if I have to allow your application, then it will be difficult.
Look, that difficult, Lordship. Yes.
Acha, let me go through.
Lordship, yes.
If I reject it, then I will pass the order.
Lordship, yes.
Okay. Show me the custody order. Or whatever, the way you want. If you want to start with FIR, okay?
Lordship, yes. Lordship, there are two vehicles involved. One is the Mahindra Scorpio.
So when was the steps taken? When were these?
So,
2-6.
2-6, Your Lordship.
No fresh notice, right?
Lordship, yes, fresh notice may be required, or we have the follow-up investigation regarding the this respondent, because we have visited his residence. Our officers visited his residence, but in his residence he was not available. Then we have interrogated with his family member. Then his family member says that they do not know the whereabouts of this respondent. But in the meantime, he had filed the application for release of the two vehicles, Lordship. And one is not registered in his name.
Acha.
And without considering the nature of the case, the learned tribunal had released the two vehicles.
Acha, and it was released to him.
It was released to him, Lordship.
Okay. Okay, let me see the facts of
Yes,
this.
yes. Lordship, the the facts of the case is that from page 7, paragraph number 2, Lordship, or I may narrate it that one also.
No, not required. Your facts, your pleadings. What about? Show me the order of custody.
Lordship.
Page number 10, 20.
20, yes, 20 is the release order.
Huh. Okay.
20, paragraph number 3. Start from paragraph number 3.
Acha, so it is a Tata Nexon and Mahindra Scorpio.
Lordship, yes. And Tata Nexon is registered in his name, and MZ01F 1845 is registered in the name of R. Vanal Siyama.
Not in his name.
Not in his name.
Scorpio is not in his name.
Yes, Lordship. MZ01F, this one is Scorpio in his name.
No, Tata Nexon is F1845.
Yes, Lordship.
MZ. So this is in his name. He is the owner.
No, Lordship. That MZ01F is not in his name.
Acha.
And the other AS, this Assam registration, is in his name. Then Mizoram registration, that MZ01F is in the other name. But the learned tribunal had released both of the vehicle to him. And Lordship, the main grievance is that at page 21, paragraph 4, paragraph 4, no objects.
I'm just reading paragraph 3 as well.
Lordship, yes.
Okay, 4. No objection is filed by the respondent.
Yes, it was reflected that no objection is filed by the respondent despite given chances since dated.
So you
because
were given chances.
No, Your Lordship, I have received the application only on 29/1/2026, which is on the same day this impugn order was passed.
So this finding is wrong.
Lordship, yes, finding is wrong. This application is at page 45, which is Annex 6.
Application by the
Application, yes.
the respondent.
Yes,
Page?
Lordship. Page 45, Annex 6.
45.
Lordship. Yes, received on 29/1/2026. That was received on that very day. I have received this application. Then I rushed to the learned special court, and it says that no objection was filed despite given chance since dated 5/12/2025.
5/12/2025.
Lordship, yes.
Maybe this is a subsequent application. He had also filed earlier applications or what?
There is no other application. This is the only application which is submitted by the respondent, Lordship.
Acha, this is filed when? Application was filed on?
Was filed on, it seems, Lordship, date is not there, but it seems that it was filed on December 2025, maybe 5/12/2025.
5
We do not know.
2025. But you received the copy on
On
29/1.
29/1/2026, on that very day, this impugn order was passed. Also, the problem is that whenever the application for release of this vehicle was filed before the learned tribunal, then I have received the copy. Then we have done some investigation to the concerned transport department to verify that whether he or she is the real owner or not. If he or she is a real owner, then we have nothing much to say because
Acha.
there is so many Supreme Court ruling in that regard.
Okay, wait. Paragraph 5, what does it say?
Paragraph 5, having perused the application as well as the case file, considering the submission by learned counsel for the applicant, it is seen that the applicant is the registered owner of the seized vehicles. However, the seized vehicles in question are liable for confiscation, subject to the outcome of the trial court, which would take some time. At present, the court has no safe place for keeping the seized vehicles or any staff to keep proper maintenance while in custody. Therefore, the seized vehicles are subject to decay. The court satisfied
So
to
it
allow
was
the
given in
application.
Jimma, and there were so many conditions also attached.
So many conditions was attached, Your Lordship.
So it is said that he was the registered owner of the seized vehicle.
But he's not a registered owner. I have the documents.
Acha, show me those.
Yes.
You have not annexed it with the application.
Lordship, so far as the Mahindra Scorpio is concerned, I have nothing much to say. Because from our investigation, he's the registered owner from the Assam DTO. And regarding this Tata Nexon MZ01F1845, registered owner is different, Lordship. In the first line, application number is there, and next registration number MZ01F1845. And second line, owner name R. Vanal Sima is a registered owner. So we do not know that the registered owner may come anytime before the trial court stating that this is my vehicle. Also, my prayer is very limited in this case. I understand this is a Zimanama order. So I may be given a chance to raise my objection before the learned trial court, and I'll submit these documents, and the learned trial court will consider. Also, if the learned trial court finds that this is not relevant, then he or she may pass any order, Lordship. But this is the commercial quantity of the heroin is involved.
But
So
then
I may be
the-
given a chance to raise objection, Lordship.
But then criminal court, the orders, after passing the order, the court become functus officio. He cannot take back the order.
Lordship, yes.
The High Court has to set aside the order.
Set aside.
But in his absence, it is difficult to set
Lordship,
aside.
yes, I understand.
Well, had it been a pure, a simple case, that could have been rejected, okay. But in his absence, I cannot allow this application, and of course, you have made a ground that this vehicle belongs to someone else. He must have purchased or something that we do not know.
We
That
do
is
not
for-
know.
that is
So
for
his
him.
presence is required, or his representative.
Okay, heard Mr. Johnny L. Tachuang, learned counsel for the petitioner.
Lordship, yes. I'm a special PP.
Learned a special PP for the Union of India.
Union
for
of
the
India.
petitioner.
Lordship.
Special PP for the petitioner. By this application, the petitioner has challenged the custody order given to the respondent in respect of 2 vehicles. That is, Tata Nexon bearing registration number MZ-01F-1845 and Mahindra Scorpio bearing registration number AS-01-BZJ-8894. Full stop. The petitioner has raised objection to the said order mainly on one ground, that the said order of custody dated 29/1/2026 was passed without hearing. You are not
Lordship.
even present, but
Yes.
then by advocate so and so before so and so. Both sides are present.
Both sides are present, it was reflected. I was not present, Your Lordship.
On the ground that he was not, the learned PP was not heard when the order was passed. The learned counsel also submits that although there is stipulation in the order that the respondent side, that is the petitioner side, did not raise objection, although chances were given since 5/12/2025, but he submits that he received the application for custody only on 29/1/2026. And that he had not, he was not given any earlier opportunities to object to the said custody. The learned counsel further submits that as far as one vehicle is concerned, that is Scorpio, the same is owned by the respondent, but as regards the other vehicle, that is Tata Nexon, but here this Tata Nexon is not written, it is Tata Motors.
Tata Motor, but it is Tata Nexon, Your Lordship.
Number is same, huh?
Number is same.
What did I say? Other vehicle? Tata Nexon is not owned by the respondent. And to substantiate this fact, he had placed the document from the district transport office. This is registration document.
Registration, Your Lordship.
That is registration document, huh? From the district transport officer, Aizol.
ISO.
However, the office note reflects that service of notice is not complete on the said respondent, and a remark was noted that address was not sufficient. As such, the petitioner is directed to take fresh steps after finding out the proper address of respondent of the respondent. Okay.
Yes.
List this matter for further consideration on
Lordship, I may be given 3 weeks' time.
14th of August.
14th of August.
14th of August.
July, Lordship.
Item number 7.
Yes, bail application, what
Yes, my
happened?
lord.
He's
Can
still
the
not
mat-
there.
Yes, can the matter be taken tomorrow?
Right, madam.
Tomorrow is a division bench day. So at 2?
Thursday also, no problem.
Yeah, Thursday, but at 2? Today try it at 2?
My lord, it seems the council has met with some accident
Oh, is
on her
it?
way, so she's having some difficult time to recover.
Oh, okay. Then we will take it up tomorrow after DB. Mr.
All right, after DV.
Mr. Courtmaster. Mr. Courtmaster. After DB, can it be listed? Okay. So tomorrow, the learned counsel for the petitioner submits that there is personal difficulty for the conducting counsel to appear, and has prayed that the matter be taken up tomorrow. That is 22nd, right? 22nd of July. Prayer is allowed, list accordingly.
Civilized. Item number 10 and 11.
10, 11, Mr. Mehdi is not free.
Online, my lord.
He said, he mentioned it in the morning. He said he has some matters in the other court. He'll finish that and then come. Okay, then we will sit at 12:30 then.
Yes, my lord.
Any other matters on board? No. This is the last matter.
5:30, Lordship, I have some engagement since there's a mediation
Acha.
sitting.
So, okay, we will take up this matter at 2.
Two.
By 2, finish it.
Yes,
Because
Lordship, that will
yesterday
be
I
fine.
took up the
Yes,
matter,
yes,
I heard
yes.
it to quite some length.
Yes.
Then it was not fair on my part
Yes,
to leave it. So I thought I'll get it today and get the matter disposed of. So at 2 o'clock you come?
Yes, my lord. Yes, your Lordship.
Okay.
Okay.
Then he'll also be free by then, I think.
Yes. Hopefully.
Any other part matters are not there? Okay, see you at 2 then. Oh, call that person? Yes. He'll have to open the door actually. Okay. Thank you. Clarified, yes.
Clarified. So this clarification has not taken, my lord, when finally, my lord. This is required, my lord. And another page, my lord, this for my satisfaction, I want to show, my lord, this. Lordship may turn page 40, 42 and 40, 43 of my,
Yes, 42.
and 43. my lord.
This one I have seen. This
My lord,
is
43 speaks, my lord, this periodic patta, my lord, 42 and 43.
2019.
My lord, it was, my lord, 12/9/2019. The other one is 11/9/2019, my lord. And my lord, they filed representation, my lord, which is I annexed in my writ petition, my lord. It was, my lord, immediately after that, my lord. Immediately after that. This,
what immediately after that?
after periodic patta, my lord. After
Otherwise, LSC is issued in the year 2005.
5 is, my lord, that LOC, the owner, that
Owner was different.
Different, my lord.
Here, as far as petitioners are concerned, they got the land in 2019.
19, my lord, 19 of particular date, my lord.
11/9.
11/9, my lord. And they filed representation, my lord, 11/9, my lord. Thereafter, my lord, immediately, my lord, they filed their representation is page 15 of my petition, my lord, on 15/9, my lord. After 4 days. After periodic patta, it is 12 or 11, 12/9 or 11/9. Thereafter 15/9, immediately after 3 days, they file a representation for claiming the compensation. This their land is they constructing road, my lord. This is the case, my lord. So lordship, my lord, this.
So they had applied for compensation for either damage or either for acquiring after 3 days of their
3 days of the
ownership of the land.
ownership of the land.
Okay, initial owner did not do anything. They can do. Where is Deba?
So that we file a writ petition, my lord. So the earlier also this it was taken because of this point we raised, my lord. The same that the verification report, my lord, it was not as per the honorable High Court order, my lord. So it is to verify whether this land belongs. That land road was constructed when they are in the position, my lord. So here record speaks, my lord, there, my lord, 2019 periodic patta is there to September 12th, my lord. Immediately after that, my lord, they prayed for this, and the district collector also advised them to go to High Court, my lord. Court means, my lord, maybe this High Court order, pass order, my lord. So, my lord, this question is, my lord, this completely, my lord, this is very we silenced because of that. The 3 document, my lord, report we silenced in the writ petition because the report was not as per the High Court order, my lord. So another thing is, my lord, this, my lord,
No, not according to High Court order, you cannot say.
because
High Court said that you verify.
But High Court says, my lord, you verify the land. Verify land means, my lord, as per my lord, lordship is aware, there must be some boundary also, my lord. So these are the land, this boundary is there. So that nothing is there, only this. Finally, my lord, lordship may turn one thing, this page, my lord, this page, my lord, this of my affidavit, my lord.
In the contempt.
Contempt, my lord, which is lordship is already done. It is, my lord, page 39, my lord. This was, my lord, this verification report was, my lord, in pursuance to this notification, my lord, notice, my lord. Notice is, my lord, page 36, my lord. Joint verification notice, my lord. Here, my lord, yes, 36, my lord. It is 18 August 2021. In pursuance to letter dated so and so, the periodic so and so is here be scheduled on 15th September. Following spot verification team is required to reconduct this spot verification and report themselves on the office of the sub-deputy commissioner Bhairavi on the fixed date of time. The relevant documents pertaining to said land should be produced. This was, my lord, this joint verification notice, my lord. There is a report is, my lord, page 39, my lord. My lord, this pursuant to the application of verification was held the land so and so on 15th September during the verification following people were present so and so as per direction land settlement or so and so
This was the last verification.
yes, my lord. Length,
Okay,
length.
that you have shown.
So,
that
my lord, whether this is verified or not, this is only they assess the assessment is there. This is the assessment. My lord. So this is, if it is, my lord, this verification report, so this is not a verification report. This is the assessment, my lord. So or this notification says the 18 August, my lord, the notice, my lord, to verify, reconduct the verification because earlier it was not agreed. And my lord, on this, and another thing I want to show another my lord, the report, my lord, which was, my lord, it was, my lord. It is page 34, my lord. Page 34. It was before that, my lord. My lord, in representative significance,
Which page?
34, my lord.
Okay, yes.
My lord, representative of deputy superintendent did not show up without giving clear information. It must be mentioned that verification in connection of some cases already been conducted on same case. This is same case. Same case conducted on 16 December 2020 and 2020, wherein it is already proof. There's proof that railway has constructed so and so railway buses so and so. However,
So it was already proved. Proud
my lord, this proof is, my lord, 16 December 2020. This is, my lord, this I am showing the first I have shown in your lordship, my lord, the page 28, 29. This is the report of 16 December 2020. The relevant portion is page 29. Whether it was, page 29 says, whether no objection has been taken by the VC from the landowner concerned.
That's 29. Okay.
Yes, my lord. That is, my lord, that is the report of 2016 December 2020, my lord. That is page 29 says, my lord, whether notification and no objection has been taken by the Bhairavi from the landowner before issuing NOC from developing existing road needs to be clarified. So whether they clarified or not, my lord, it was not reflected in this verification report and subsequent report also, my lord. And my lord, very much clear, my lord, this.
No, that is actually no objection. But the fact of your using the land as road
Yes, my lord.
was stated to be proved.
Yes, my lord, stated to be proved, my lord, this, my lord, when the as per NOC 2015, before the land was purchased by the married person. And another thing is there is two plot, my lord, one is his wife and one is his land.
Husband.
So wife was not the paid petitioner before this honorable court, my lord.
Wife is also a repetitioner.
No, my lord. No,
only
my lord.
husband has come.
An assessment was made, my lord. Finally, the assessment was made.
Assessment was made by the collector.
Yes, my lord. The collector, my lord, page 58 of my affidavit, my lord.
58.
8, my lord.
Yes.
First one is the petitioner, second one is the wife, my lord. So this, my lord, this whether this red petitioner's land is, it is not his land, my lord. So this assessment is also wrong, my lord. This.
Acha, this assessment is with regard to damage.
Yes, my lord.
They will not acquire the land, right? You will not acquire.
My lord, this first their direction was the whether railway acquired the land. Second, my lord, if not acquired, then damage, my lord. And thing is that today in the morning I took instruction, my lord. What happened? There is a road, my lord. The villager uses this land, my lord. Road, my lord. Subsequently, my lord, this with permission of the village council as well as the deputy commissioner Kulaship, this no objection taken. We developed the road, my lord, for the village purposes as well as. Now we are not using that road, my lord. It is completely used by the villagers. We are not. But
then the damage that you have done.
But not damage, man. It was earlier. It was there. It was already reflected in the report also, my lord. This report speaks, my lord. This report initially, my lord. These page 28 observation.
Acha, whatever it is, this page 58 is for damage compensation, right?
Page 58 damage for the compensation.
48 lakhs 42,000.
And
to
yes,
husband.
Yes, man.
And to wife 3 lakh 22,000.
Yes, my lord. So this is not as per High Court order, my lord. This because High Court says this to verify the petitioner's land, my lord. So it, how contempt lies, my lord, this, because if they are aggrieved, my lord, this, they may file separate writ petition, my lord, they will reply, my lord. And some, and we are challenging that said, not revision report. And
Okay, let me dictate the order. If you have something to say, if I go somewhere wrong, then you have something to say.
My lord, yes, I would
I have not decided. I'll just dictate. Let's see what happens.
Okay.
Oh, yes, you wanted to say something?
No.
Achha, I'll start dictating. Okay, heard, miss. Wait, what is your name?
Valentina Dinpui, my lord.
Valentina
Sorry.
Lempu, learned counsel for the petitioner. Only one petitioner.
Yes, my lord, only one.
Only
petition.
the husband. For the petitioner. And Mr. Sanjay Kumar Medhi, learned counsel representing the railways. That is respondents number
6.
6. Respondent number 6.
5 and 6, my lord.
5 and 6. And Miss Venishami, learned counsel representing respondent number? Yeah, there?
No, my lord, I have the respondent number 1 to 3 in the WPC.
Achha, no, contempt I'll finish first.
Respondent number 1 and
1 and 3. Okay, respondent number 1 and 3. You have something to say? You are for the DC
I'm for the DC and the secretary.
and the secretary.
Yeah.
Here, what I can see is that the district collector has computed the assessment
Yes,
amount.
yes.
And you had also sent it to someone.
Yes, yes.
For,
to
for
the
as a
secretary.
further step.
To the
So you are
secretary.
agreeable to pay compensation to the petitioner.
Yes. And,
And
as
the
per
compensation has to be paid by the railways.
yes, Lordship, that is the finding of the verification.
Mm.
Yes. And they have complied with the judgment and order. That is the 13/9/2022.
No, judgment and order was dated. Who has complied? with it?
19/3/2020.
19 March 2020.
Yes.
So according to you, they have complied with
Yes, they have complied with the judgment and order
by.
by the DC and this.
Oh yes,
secretary,
they have
yes.
complied with. What
Yes.
about the railways?
Yes,
You say
yes.
no, nothing.
Nothing else, Lordship. That we have complied with the judgment and order.
Oh, okay. And Mrs. So-and-so for respond number 1 and 3, right? This is an 1 and 3, yes. This is a contempt application filed under Rule 9 of the Contempt of Courts, within bracket Gauhati High Court, Rules 1977, read with Section 12 of the Contempt of Courts Act 1971. Along with Article 215 of the Constitution of India, full stop. The petitioner has claimed that the judgment and order dated 19/3/2020 was not followed or complied with by the respondents. It is the case of the petitioner that the petitioner had filed a writ petition. Writ petition was by you, right?
Yes, my lord.
148
Yes, my lord.
was filed by the writ petitioner, being WPC number 148 of 2019. For compensation and damages.
For verification of the damages upon my land and to pay compensation or the damage compensation, my lord.
Yes, for, what did I say? Writ petition number so-and-so, praying inter alia, that the respondent, more specifically the railways, should pay the compensation, should pay the damage compensation for the damage done on their land, as well as on their land. That is the only
Yes,
compensation.
for the acquisition of my land and damages caused upon my land.
As well as the compensation to be given to them in case the railways acquire the said land for its purpose. Full stop. The learned court, by order dated 19th of March 2020, had directed that a verification team should be constituted by the Secretary to the Government of Mizoram Land Revenue and Settlement Department consisting of the district cum deputy commissioner, district collector cum deputy commissioner, Polasiv, and or its representatives, comma, the deputy chief engineer, construction, within bracket, NF Railway, Silchar, Kachar, Assam, or his representatives, and the petitioner. Full stop. The said verification team was directed to be constituted to verify the lands of the petitioner within a period of 1 month from the date of the receipt of the order. Full stop. The High Court had further directed that the verification team further directed that if the verification team finds that the land of the petitioner have been used by the respondent number 2, that is the railways, for constructing a road, then the railways shall take a decision from 2 weeks from the date of the verification. No, within 2 weeks from the date of the verification, as to whether they want to permanently acquire the lands. It is thereafter directed that if the railways decides to acquire the land, it should give requisition to the concerned authorities for acquisition of the land. And as per the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013, the railways, not the railways, an award may be made within a further period of 2 months. The court further directed that if the railways decides not to acquire the lands, then they should stop using the petitioner's land forthwith. And in the event respondent number 1, who is respondent number 1? Government.
Yes, the government, my lord.
In Revenue Department.
In the writ petition, yes. District collector, yes.
District collector. Okay, in the event the district collector, arrayed as respondent number 1, shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the railways, and the amount so computed shall be paid to the petitioner, yes, by respondent number 2, that is the railways, within a further period of 1 month from the date of assessment made by the district collector, cum deputy commissioner. Which is the place? What is the place, counsel?
Kolasip.
Kolasip. The learned counsel for the petitioner submits that the said directions given in the order dated 19th of March 2020 were not. No. First of all, you say, learned counsel for the petitioner submits that the said order dated 19th of March 2020 was communicated to the Secretary, Land Revenue and Settlement Department, New Capital Complex, Aizawl, Mizoram, by the petitioner by the letter dated, through the letter dated, you can say, letter dated 9th of September 2020. Full stop. Learned counsel further submits that in pursuance to the said order, a notification was issued on 15th of September 2020 by which the Secretary to the Government of Mizoram, Land Revenue and Settlement Department, notified that the verification team is constituted to verify the land of the petitioner covered by periodic patta number 501861/10/58 of 2005. Full stop. It was further notified that the said committee would find out whether said land covered by the said periodic patta was damaged by construction of the approach road by NF Railway. Full stop. The committee consisted of the Deputy Commissioner within bracket Kolasib or his representatives, comma, Deputy Chief Engineer Construction, NF Railway Silchar Assam or its representatives, and the owner of the said plot of land, that is the petitioner. What is this RTI application, Ms. Counsel?
This is the
Page
RTI
18A?
submitted, yes, submitted for the assessment copy, my lord.
The result of this meeting?
No, the assessment, the damage compensation that has been assessed.
Achha, this was much after.
Yes,
the
much
meetings
after.
and all.
Yes.
Okay.
So a copy of the assessment was obtained via the RTI, my lord.
Okay. The learned counsel, however, submits that she is unaware. Oh no, that the petitioner is unaware as to what happened after the said notification was issued. You did not know, right?
Regarding the assessment, my lord.
Assessment you know, but what happened in these meetings, vagera, you did not know.
There was no meeting, my lord. We applied for the information regarding the amount of compensation that was awarded.
The learned counsel further submits that by an application under the Right to Information Act, the petitioner was apprised of that compensation was computed with regard to the damage done on his land. Fixing an amount of rupees 48,42,000 to be given in respect of the land covered by periodic patta 58 of 2005 and an amount of rupees 3,22,800 computed as damage done on the land covered by periodic patta number 59 of 2005. That is for the land owned by the petitioner as well as the other land owned by the wife of the petitioner. The learned counsel therefore submits that although computation was done, the said amount has not been paid to the petitioner as well as to his wife, and there is a violation of the order dated 19th of March 2020, in which it was specifically directed that on damage being assessed by the district collector, respondent number 2, that is the railways, should pay the amount to respondent number 2 within a specified period of time. She submits that there is willful violation of the order dated 19th of March 2020 by the respondents concerned. This is your case, right?
Yes, my lord.
Full stop. On the other hand, Mr. S.K. Medhi, learned counsel for the respondent number 2, that is the railways. Learned counsel for the railways, representing respondent number 5 and 6, submitted that pursuant to the said order dated 9/10/2017, 9/10, right? Pursuant to the said order dated 19/3/2020, a verification committee was constituted I had written notes yesterday. No, I had written notes yesterday. There will be 2 pages. Yes, where did you get it? Yes. No, this is not the one. No. This is in respect of another case. Oh, yes, I got it. Submitted that what verification team was constituted, right? Constituted. On pursuant to that order, verification team was constituted by notification dated 15/9/2020. Where is that constitution of the verification team? In your affidavit, right?
Affidavit is my learned place. Isn't one.
No, you had given somewhere your this in the affidavit, I think.
Affidavit,
I have annexed in my petition, my lord, the verification team constitution.
That is there. That is
Yes.
the first one.
Yes.
Then constitution of the verification team is there. No, the results of those meetings.
The verification.
The first meeting which ended in their objection, where did I find it? In his affidavit.
Page 30, my lord, of my lord, affidavit, my lord.
This is joint verification notice.
Yes.
No, this is no objection certificate. No.
They have said again page 36, my lord.
Page 20, I think page 28.
28 is one, my lord. 28, my lord, this is the report, my lord.
That is what I'm saying. Report.
Yes, ma'am.
Report of the first meeting
Yes, ma'am. 16 December 2023.
was constituted on so and so, and the meeting was conducted on 16th of December 2020.
Is not meeting, my lord, the report on the verification.
On verification, my lord.
A meeting was held when?
It was not meeting, my lord. A verification was held.
Verification held, my lord.
Verification of lands was held, my lord.
Yes, where is that?
My lord,
This 16 December?
Yes, 16 December 2020 is the first.
this is the report, my lord.
That is the report.
Acha, a meeting was conducted before that.
Yes, verification was conducted on 11/12/2020 as per the submissions made by the
Yeah,
respondent
it's in
number one.
pursuance to the order number so dated 11 December 2020.
Yes, ma'am.
Yes,
A joint verification in respect of period. Acha, what did I say? It was constituted. And thereafter, a joint verification was done in respect of the land of the petition, in respect of the land in issue. That is land covered by Patta number 58 of 25 and 59 of 25. And a report was submitted on 16th of December 2020. Oh, cut the earlier line. A report was submitted on 16th of December 2020. In the said report, it was stated that during the verification, the representatives of the railway were present, as well as only railways and the owner were there in the said verification.
all the parties were present in the first verification, my lord.
But then see, during the verification, Mr. Satya Prakash,
Yes, my lord.
Senior Section Engineer, NF Railway,
Yes, my lord.
representative of
NF Railway.
NF Railway,
Yes, my lord.
and the appellant was there.
Yes, and the petitioner was there. Yes, my lord.
Acha, what did I say? Representatives of the railway and the appellant and the petitioner were there. And that both the parties submitted relevant documents in the connection thereof. Full stop. Arguments were also made by both the parties and the same were and jotted down in the said report. Full stop. The petitioner during the said verification had stated that railway had constructed road through his land, mentioning both the land under periodic patta 58 and 59 of 2005, and that the railways had damaged his land and had also caused damage by dumping the soil. He further argued that the railways had not given him any compensation for the damage caused and that he was not aware that railway would be constructing road through his land. And he measured the land which is damaged by the railways as 900 meters approximately. Full stop. During the verification, the representative of the railways had argued that railway started work for repairing of existing road after obtaining the no objection certificate from the Deputy Commissioner Kolasit dated 6/2/2015. It was also stated by the representative of the railway that the allegation of dumping soil on the said land raised by the petitioner was in fact construction material for improvement of the said road. And also that 6 years had gone by since the work had started, that is, development of the road. No objection was raised during that period. On the basis of the argument made by both the parties, observations were recorded in the report. Wherein it was inter alia stated that the road existed on the day of verification and the same had passed through the land of the petitioner, and that the said road was utilized by the railways. It was further observed on the contesting claim by both the parties as to whether the road had existed prior to the railways coming into the picture. The observation was made that the same needs to be clarified with the then village council president, or what? VCP is what?
VCP is the village council president, my lord.
Clarified with the village council president of the concerned area. Full stop. Also on the submission that the railways had obtained no objection certificate from the village council, an observation was made as to that observation was made as to whether no objection was taken by the said village council from the landowners also needs to be clarified. However, during the verification, the settlement officer was not represented, and as such, the actual area of damage could not be ascertained. Para. Thereafter, a re-verification was directed to be conducted in respect of the same issue, and a meeting was scheduled. And the said re-verification was scheduled on 5th of February 2021. And a verification team was constituted with members which VIZ dot the SDC is what? Subdivisional? Sub-deputy collector. Sub-deputy collector or representative of this deputy collector, Kalasip, settlement officer or her representative comma, Deputy Chief Engineer, NF Railway Silchar or his representative, and the appellant and the petitioner. It was further directed by, this was declared by issuing a joint verification notice on 1st of February 21. And in the said notice, it was directed that the verification report be submitted to the Deputy Commissioner, Kolasib District. So thereafter, what happened? 5/2/21.
Verification could not be conducted, and as per the submissions of the respondent number 1 in annexion number 3.
Acha, one second. 1/2/2021. Okay, yes. However, the verification could not be conducted on 5/2/2021 as directed. And that the said verification was again fixed on 23/3/2021.
Next one.
23/3/2021, right? And pursuant to the and the verification was in fact done on the said day.
Railway is not present.
And during the verification, what is PTT settlement officer? Okay, this is a name. During the verification, the settlement officer of Kolasib, representative of the district collector, Kolasib, the sub-deputy collector, comma, the surveyor, and the petitioner were present. And a report was submitted on the same day itself. Full stop. In the said report, it was however stated that during the verification, the chief engineer, deputy chief engineer, construction, NF Railway, was not present. Further, in the said report, it was stated that verification was already done with respect to the land on 16th of December 2020, wherein it was established that railway had constructed road in the lands of the petitioner, which passes through both the lands, being periodic patta number 58 and 59 of 2005. And it was also found, no. As representative area was not as Kolasib did not, as per the verification conducted in one, it is confirmed. And it is further stated that the total length of road passing through the petitioner's land is 930 meters in length. And the total area of damage caused to the said land caused by railways is 23301 square meter as per calculation from Google Earth. It is further mentioned in the said report that damage is done to the land of the petitioner by dumping of soil, and that trees have grown on the same, and an estimation was made that damage area would be approximately 26,000 square meter. Para. Thereafter, the Deputy Secretary to the Government of Mizoram, Land Revenue and Settlement Department, requested the Deputy Commissioner, Kolasep District, to reconduct spot verification in respect of the said lands, in presence of the representative of the NF Railway. Representatives of the railways, you can say. And the Deputy Commissioner, Kolasep District, had ordered for a re-verification on 15th of September 2029. And constituted a team by a joint verification notice dated 18th of August 2021. No, 15th of September, right? I said 15th of September, na first, yes. Okay, by a joint verification notice dated so and so, 18th of August 2021. But on that day, verification could not be done, right? And you did not write. Yes, Council, that day verification could not be done, right?
My lord, day after, my lord, 15th September it was done, my lord.
Huh?
15th September it was done, my lord.
The final verification was done on 15/9, my lord.
39.
15/9.
Yes, my lord.
So, DC ordered for 15/9 only?
Yes, my lord. It was done, my lord.
This 15/9?
Page 39, my lord, this
Acha.
report.
Okay. In pursuance to the said notice, verification was done on 15/9/2021. And during the said verification, the representative of the railways was present.
Only assessment was made, my lord. No verification.
And a report was submitted on the same day itself.
My lord, 15/9, my lord. This is
Same.
Page 39.
Report was submitted on the same day itself. Full stop. In the said report, it was stated that assessment was done in respect of the said land, in respect of the damage caused to the said land, and the area of damaged land measured was 1200 square meter in respect of land covered under periodic patta 59 of 2005, and in respect of the other land covered by periodic patta 58 of 2005, the area of damaged land was measured to 18,000 square meter. Full stop. However, the representative of the NF Railway refused to sign in the said assessment sheet. Full stop. The representative claimed that the issue of assessment was not mentioned in the notice, and that he, being the representative of the railways, cannot take any decision by himself on spot.
Before that, my lord, there is one paragraph, my lord. As per direction of land revenue department, so and so, damage, the assessment of damage was carried out, my lord. My lord, there is no such, my lord, the line, this is the verification, but notification speaks, my lord, this, they reconduct this spot verification and report themselves, my lord. So this is there.
Okay. it is also stated herein that the said assessment was done as per the direction of the Land Revenue and Settlement letter issued on the same subject.
My lord, it's 18th August 2020.
Where is that date?
My lord, this, it was, my lord, reflected, my lord, this, first, as per direction of Land Revenue Settlement letter, C, so and so, my lord, same is reflected, my lord, here, my lord. Page 36, my lord. In persons, letter number C, 1801730, my lord, this one, my lord.
No, wait. Where did you get the said number? 1807?
My lord, this, my page
Yes,
36,
yes.
my
In
lord.
pursuance to the letter. Okay. REV, same, no? 2000. No, this is 13 and
My lord, there's a 13 is a typographical mistake, my lord.
Is it?
Yes, my lord, it is in the 37, it is reflect 19, my lord.
Acha, acha.
39.
Okay. Dated, you
37.
give dated 3/8/2021. In the said report, it is further stipulated that railways do not agree with the findings of this note. The Learned Counsel for the Railways further placed reliance on the no objection certificate given by the president of the village council. Now see, your translation is incorrect.
Yes, my lord.
See page 40 and 41.
40.
40 and 41.
No, my lord, this is, my lord, from the deputy commissioner, my lord.
Acha, this is
And
for
that,
deputy
actually,
commissioner.
I forgot to say this village council one, my lord.
Acha,
second-
41 is village council.
Yes, my lord.
Okay, place reliance on the no objection certificate issued by both the Deputy Commissioner Kolasip District as well as the President of the Village Council. Wherein it was stated that the land on which the road was repaired and developed by the railways was owned by the village council. He submits that the said land was not owned by the petitioner so as to claim the compensation for the same. He further submits that the petitioner came into the picture as owner of the said land in 2019 and that the railways had started developing the said road when?
My lord, railways.
In the year 2015.
15, my lord.
In the year 2015.
Vidi Patta is, my lord, 2019, my lord, September, my lord.
I said 2019. He further submits that the order of this court dated what?
19/3/2020.
19/3/2020 was not disobeyed inasmuch as the verification was not done as per the said order. And accordingly, the compensation that was computed with regard to the damage of the land cannot be claimed from the railways. That is what you want to say?
Yes, my lord, we have, there's a,
Verification was not done according to the
yes, my lord.
order. Accordingly, he submits that there is no contempt committed
And my lord, the assessment was also made, my lord.
by the railways.
Wife also, my lord. The assessment also wiped the repetition as well as wife.
He also submits that assessment was done not only in respect of the land damaged,
Of the
not only in respect of the damage to the land of the petitioner, but also to the land owned by the petitioner's wife, also to the alleged damage to the land owned by the petitioner's wife. The land covered by the periodic patta number 59, wife is 59.
59.
Yes, my lord.
59 of 2005, which was subsequently owned by the wife from 2019 onwards, was not mentioned in the order of this court. And as such, the assessment computed with regard to the said land cannot be asked from the respondent to pay. It was not there in the order, so you were not supposed to pay, right? Full stop. Para. The learned counsel for the petitioner, however, in reply to the submissions made by the learned counsel for the respondent, for the railways, submits that the land covered by periodic patta number 58 and 59 of 2005 were owned by the erstwhile owner who sold it to the petitioner and his wife. And the name of the erstwhile owner is the son of somebody you had shown?
Yes, my lord. At page number 31 of the writ petition, my lord.
Writ petition?
Yes, the owner's name is annexed at the
31.
Yes, on the writ petition. Yes. Yeah, yes, your writ petition.
31? 31 is an affidavit.
No,
Writ petition.
the
Oh, writ petition. No, writ petition is by him. Where had you shown it? From the affidavit?
no, sorry, affidavit filed by the NF, my lord. My writ petition next year is again annexed by the NF Railways in their affidavit.
Affidavit of 24th February?
Yes, 24th February.
Which page?
Page number 13. I will spell it out, my lord, since it's legible.
Zoram Suyama.
Zorem Siama, yes. Type out copy.
Father's name is Langivita. Huh?
C dot TLANG HMING.
And where is the sale date?
THANG.
Where is the sale date?
The sale date is at page number 24.
24.
Type copy.
She submits. What did I say last line?
My lord, there were two honors. Previous honors, yes.
Two honors?
Yes, my lord. 58 of 2005 was owned by Zorem Siama, and 59 of 2005 was owned by Tlang Ming Thanga. Si
The
Tlang.
father and son?
The father and son, yes.
Father and
so the father sold it.
Yes, father sold it.
Yes.
Okay, so, okay, full stop. She further submits that the said land covered by, covered by patta number 50, where is that patta number here in page number 13?
At page number 13, page number 13.
Yes, yes. Patta number 58 of 2005 was owned by one Zorem Siama, ZOREM SIAMA, son of C. TLANG HMING Thanga, THANG, Thanga. And the periodic and the land covered by periodic patta number 59 of 2005 was owned by C. Same name, Langming Thanga. Langming Thanga. Full stop. She submits that it is C. Langling Thanga who had sold the property to the petitioner. proper. Acha, this C. Langting Thanga has sold which plot of land to petitioner?
58 and 59.
Both.
Yes, my lord.
But the son has to sell, right? 50, as far as 58 is concerned.
It seems there was no objection, my lord, hence the mutation was
She
completed.
further submits that it is C. Langting Mangthanga who had sold his property covered by Patta number 59 of 2005 to the present petitioner, and had also sold the other plot of land covered by Patta number 58 of 2005 to the petitioner only.
Petitioner only, my lord.
But then the wife is the owner.
My lord, so I would like to clarify that again. At the time of filing the WPC, the mutation was not completed. So I had to come to the court using the sale deed and the previous owner's name.
Acha, mutation was done later and it was in the name of the mother, of the wife.
Yes, so mutation was, I gave one of my land to my wife.
Acha. Okay, she further submits that the mutation of the plot of land covered by periodic Patta number 59 of 2005 was done in the name of the wife of the petitioner. As such, she submits that it is not a case where the land was owned by the village council till the year 2019, when the plots of land were sold to the petitioner. But the same were owned by erstwhile owners as mentioned above. She also submits that the land was converted to periodic patta in the year 2005 itself.
No, my lord.
Oh no, LSC.
No. The erstwhile owners have already owned the land since 2005 under the same periodic patta numbers.
Okay.
So there
you
was
don't
no
have to write
question
the
of
last
whether
line.
or not the village
They were
council
owned
had-
by the erstwhile owners.
Yes, since 2005.
Under the same periodic patta numbers. She therefore submits that the road that was used and developed by the railways went through the land covered by periodic patta number 58 and 59 of 2005, which were purchased by the petitioner in the year 2019.
2018.
But he showed me 2019.
2018 is the sale deed, my lord.
Okay, 2018,
Yes,
when
ma'am.
the sale deeds were executed. She further submits that when the order was passed by this court on 19/3/2020, the petitioners were owning the said plots of land. Petitioner and his wife.
Yes.
Petitioner and his wife were owning the said plots of land. And there is no bar for the petitioner and his wife to claim the compensation for the damaged part of their land. I've heard the counsels and I've gone through the documents very carefully. Full stop. The order of this court on 19th of March 2020 shows shows that the learned counsel for all the parties were heard. And it was specifically written that the counsel for respondent number 2 had no objection to the prayer made by the petitioner's counsel. And on the consent of all the parties, the said order was passed. By the said order, this court had directed the Secretary to the Government of Mizoram Land Revenue and Settlement Department to constitute a verification team consisting of the representatives of the district collector as well as the railways and the applicant and the petitioner. Who would verify the lands of the petitioner and on verification, if the lands is seen to have been used, is found to have been used by the railways for constructing a road, then the railways were directed to take a decision to acquire the said land as provided under the law. And if the railways decides not to acquire the land, appropriate compensation should be paid to the petitioner. In pursuance to the said order, a meeting was held. A verification was conducted after a team was constituted. And upon verification, a report was submitted. On 16th of December 2020, in the said report, it was stated by the representative of the railway that they had started repairing the road, existing road, on obtaining a no objection certificate from the Deputy Commissioner Kolasip, dated 6/2/2015, and that the dumping done on the said land was for improvement of the road. Full stop. The committee, after hearing the contentions of all the parties, had reached a finding that the approach road had passed through the land of the petitioner and the railways were utilizing the said road and was developing the same. As such, it is it is found that the railways was using the said road and was developing the same, and the said road went through the land of the petitioner. In the said report, it was also stated that whether there was any road used by the people before the railway starting using it has to be clarified from the village council president of the said area. And it was also stated that whether the railways had obtained, whether the no objection was taken by the village council from the landowners should also be found out. Full stop. However, the fact remained that in the first verification itself, findings were reached that land of the petitioner was damaged by the railways. Full stop. The assessment could have been done then and there itself. The assessment would have been done then and there itself, but due to absence of the settlement officer, the actual area of damage could not be ascertained. Now, the railways cannot turn around and say that damage was not done by them on the land of the petitioner. Due to the fact that they were utilizing the said road and had dumped and damaged the area used thereof. In the said report, it was stated that railways had objected to the said facts in view of the further fact that they were constructing the road from 6 years, but there was no objection from any quarter. Full stop. However, that cannot be a ground for non-payment of the compensation or assessment amount to the petitioner. in view of the absence of the assessment, in view of the absence of the settlement officer, a re-verification was done. A re-verification, I always forget. Re-verification was done on which date?
15-9.
15-9. Re-verification one was done.
Before that, there was one verification which was called but could not be completed.
No, it's okay. That
That
was already in the
yes.
facts. So re-verification was again done on 15-9-2021. And a report was also submitted on the same date, wherein it was again stated that railways had constructed road on the lands of the petitioner, which passes, land of the petitioner, covered by periodic patta number 58 of 2005, and the land of the wife of the petitioner, covered by periodic patta number 59 of 2005. And in the presence of the settlement officer, the damage was calculated, was assessed, was, and by the said report, no? What did I say? Last line? Officer, the road constructed by railway on the petitioner's land was measured as 950 meters in length. And the total damage caused to the said land was also measured as 23301 square meter. Full stop. It was further calculated. Along with the same, the damage was calculated to cover an area of approximate 26,000 square meter. This is 23rd of... No, this was 23rd of March.
23rd March, yes. I was just going to correct
Yes,
that.
so that was 23rd. Acha, you do one thing. Instead of 15-9, you write 23rd of March 21, huh? So why was it not accepted and another meeting was held?
Because the representative of the NF were absent
Oh,
at that
yes,
time.
yes. Full stop. However, during the said verification done on 23rd of March 2021, the representative of the railways were not there. And as such, a new verification was conducted. And in the said verification notice, a letter issued by the Government of Mizoram Land Revenue and Settlement Department dated 3/8/2021 was mentioned in the same. And a re-verification was scheduled on 15th of September 2021. Full stop. On 15th of September 2021, a joint verification was again held in the presence of the representative of the railway. And a report was prepared. And in the report, the damage measured in respect of periodic patta number 59 of 2005 was fixed at 1200 square meter, and in respect of the other land, it was fixed at 18,000 square meter. Coming to a total of 1,93,750 square feet. Now this is feet. Total is feet.
Yes, my lord, it seems from the
feet.
report.
Full stop. In the said report, the representative of the NF Railway refused to sign in the assessment sheet on the ground that assessment was not mentioned in the notice. Full stop. Or not full stop. But the same cannot be considered to be a valid ground, inasmuch as the letter issued by the Government of Assam, or Government of Mizoram, Land Revenue and Settlement Department was mentioned in the said notice, which was for assessment of the damage that was carried out. An assessment of the damage that was already found in the previous verification. It can be clearly seen that the subsequent joint verification conducted on 15/9/2021 was only with regard to assessment of the damage that had occurred in the lands of the petitioner. The said purpose was already mentioned in the joint verification notice, but the representative of the NF Railway either had not noticed the same or is deliberately refusing to accept the assessment.
Yeah, man, it is not fully mentioned, man, in page 36, man.
No, why? This is, in fact, you had pointed out, I did not notice. This is, see, in portions of the letter so-and-so, 3821, you said that this is the same letter. So, see page 39, as per direction of so-and-so, assessment. So, this letter was only with regard to assessment, because other things, your construction of land over the land were all
I understand,
established.
but letter speaks, my lord, otherwise, my lord.
Where is that letter? 38?
This, my lord, page 36, my lord.
No. Where is that letter of 38/2021?
My lord, this is 36 page, my lord.
No, it's not. It's a letter of 18th August 21.
My lord, this reflect, my lord, this in
This is what I'm saying. You show me the letter dated 38/21.
Yes, my lord. 38,
It's
my lord,
not there, perhaps.
38 is page 35, my lord.
3835. Submit the report along with an award assessment to the undersigned.
Your request, I have directed to
So assessment was there, was the subject there. And now he's saying that assessment was not in the issue. He claimed that assessment was not mentioned. This is wrong. This is what I've said. Acha, where is the assessment done by the deputy collector? It is in your petition.
Yes,
In his petition also. In his reply
petition also, my lord.
Where is that? What is the page in his petition?
My affidavit,
Oh,
my
yes,
lord,
page 54.
54, my lord. 54 owners.
A full stop para. This court has further noticed the statement of has further examined likho, huh? Examined the statement for assessment of compensation prepared by the committee, right? The committee, settlement officer, surveyor, village council, which committee comprising of the members of these comprising of the surveyor, comma, the settlement officer, president of village council.
Village council is not there.
President of village council is there. Third one,
Which page, my lord?
page number 54, your page 54.
Oh, yes. Yes.
Third signature, president of VCP,
Yes,
president of village council, president of village council. And it was assessed. No, and it was decided that in respect of the land covered by periodic patta number 58 of 2025, the damage compensation should be calculated at rupees 25 per square feet or meter?
Feet, my lord.
Feet. And the damage area comes to a damage area comes to, there are two things, see, stage
Yes.
area volume comes to 1,93,680 or what?
That is in square feet, my lord.
The other one is square meter.
The first one is 18,000 square meter.
Okay.
The damage area is 18,000 square meter
As a damaged area, you write 18,000 square meter.
for periodic patta number 58
Uh-huh,
of the
yes. And in respect of the land held under periodic patta number 59 of 2005, the damage area is calculated at 12,000 square meter and an amount was assessed for the said damage as 3,22,800. Full stop. After the said assessment was calculated, acha, the DC had given it to some other authority. Where is that? It is
At
in
page
his,
number 53, my lord.
of his affidavit.
Of his affidavit, yes, my lord.
And what did I say? Concluded. The settlement officer, Land Revenue and Settlement, Kolasiv District, Kolasiv, by letter dated 23rd of September 2021, had intimated the Deputy Commissioner and District Collector, Kolasiv District, that assessment has been done in respect of the said lands for causing damage on the same, and the calculated amount was fixed at rupees 51,64,800. Acha. Just before that, last sentence you write, just before this sentence, the said assessment was approved by the district collector, Kolasiv District, Mizoram. Full stop. It is in the order dated 19/3/2020 that after the assessment, the damage amount should be given to respondent number 1 by respondent number 2 Oh, should be given to the petitioner
Yes, to the petition.
by respondent number, by the railways. You cut that, huh? 2 and 1. To the petitioner by the railways within a stipulated time. Now that the amount has been assessed, now this is a contempt jurisdiction. Punishing Vagera will not.
My lord, the sum.
So you have to pay.
Lordship may give observation, my lord.
Time frame may be given, my lord, because
Time
it
frame,
has,
you have
yes,
to pay it.
Yes.
2022.
Yes, I'm not taking any action under the Contempt of
Yes,
Courts
madam.
Act. What do you say, Ms. Venetiami? Contempt of Courts Act provides for punishment only.
Yes, my lord.
Yes.
So if my lord shows leniency, then at least time frame within a specific period of time, say 2 weeks or 3 weeks, payment may be made.
So, my lord, some time will be given on the.
And in fact, I think Supreme Court has said that instead of putting somebody in jail,
Yes.
if some other order can be given.
Yes, a fine can also be
Your Lordship,
given.
if I may, in my humble opinion, on perusing the WPC filed by the petitioner, that is the railway, even there, even in the writ petition, they admitted that there is a damage which has caused by them. And the only issues which they have raised is regarding the verification. And that verification cannot be challenged at this moment because the verification is done as per this honorable court order.
Yes.
So if they want to make that one, they can do in the contempt application. So that is also done by them. So now the only option what we can do is that if the contempt may be closed with a direction giving them a time frame for payment.
Closed.
Payment to
Closed
time frame.
No, writ petition will be dismissed.
Yes, the
in
writ
view of this
petition.
contempt.
Yes.
I'll give them a time frame to give.
Yes, madam.
Yes.
Right. Okay. So, right? Huh. Give me contempt of courts act. Contempt of courts act. It is not there. Under the Contempt of Courts Act 1971, more specifically under Section 12 of the said Act, the contemner, Court Act 19, the on proof of contempt committed, the contempt of a contemner may be punished with prescribed punishment provided therein. Which entails aside for a period of 6 months
My lord,
or with fine which may extend to 2,000 rupees or with both. The Supreme Court It is further provided that an accused person or the contemner may also be discharged or the punishment awarded may be remitted on apology being rendered by the said contemner to the satisfaction of the court.
well, before that, my lord, he said the contempt proceedings will be required, my lord.
One second.
Before
Contempt
punish-
hearing.
Contempt, my lord, contempt, initiation of contempt proceeding is required, my lord, before that. So, lordship may direct, my lord, this within a period of 6 weeks to pay the amount, my lord. Because this proceeding, my lord, this initiation of contempt proceeding, again, notice will go, my lord. And then thereafter, my lord, the court will decide whether contempt is there or not.
No, I'm just looking for further provisions. What are these? However, the Honorable Supreme Court had held that instead of punishing under the contempt jurisdiction, a court can pass restitutive or remedial measures to enforce compliance or to rectify the wrong committed. This will cover, I think.
Yes, ma'am.
Wrong committed. Any judgment to that effect? Do you have?
No, I have, right now I
Okay, I'll
have.
find out and I'll insert it. Okay. As such, this court finds it fit that respondent number 5 and 6, that is the railways,
My lord, now 6, my lord.
respondent number 6, that is the
Deputy Chief Engineer, Railway.
that is the Deputy Chief Engineer Construction NF Railway. No, he should not be held liable. Railways will pay. The department will pay.
Yes, my lord. Railway.
It finds it fit that the railways, that the Department of Railways,
No, NF Railways, my lord. Northeast
Northeast
Frontier
Frontier Railway,
Railways, yes.
that the Department of NF Railway,
He is represented, my lord. My lord, it represent is NF Railway represented by Deputy Chief, my lord. So NF Railway, my lord.
NF Railway,
NF Railways.
the Department of NF Railway,
Yes.
the concerned official in the Department of NF Railway.
Yes.
No, again, if that official comes, then he'll have to give it from personal thing. So I'm placing the area on the railways.
My lord,
So it is this court deems it fit that the Department of NF Railway,
my lordship may say, my lord, in petition it says represented by Deputy Chief Engineer, Construction.
represented by Deputy Chief Engineer,
In petition.
Construction, NF Railway,
It
should comply with the direction given in the with the direction given in the order dated 19/3/2020 to the effect that he should pay the petitioner.
Railways should pay, my lord.
That the railways,
the NF Railways
that the NF Railway should pay the petitioner the assessment amount, the assessed amount for the damage caused on his land within a period of
2 months.
3 months. Huh?
2 months, my lord.
2 months, okay.
2 months, yes.
You said 2 months, okay.
Yes.
I was thinking within a period of 2 months
Well, 3
from the
months.
date of receipt of this order.
Yes, my
3
lord.
months, my lord. My lordship.
Within
2
a
months
period
is-
of 3 months without fail from the date of receipt of the certified copy of this order.
Yes, my lord.
The petitioner is directed to submit a copy of this order or not required.
If
Not
they
required, my lord.
submit,
They
my
have
lord,
already been
We'll
represented. so-
place, my lord. They will also my placement.
The learned counsel, the petitioner is also given liberty to place the copy of the judgment before the authorities in the NF Railway. Petition is disposed of. Assessed amount, I'm not talking of the exact amount, but whatever is assessed. Or I
My
have
lord,
to give
if
the
it may
amount.
be kindly reflected because that was done as per the order state.
Okay, assessed amount, which was fixed at, where was that?
Page
The
number
deceased letter?
58.
No, in his affidavit.
58, my lord.
58, my lord.
Yes. Your affidavit has in fact helped in every terms. 58, yes.
Yes, my lord.
What did I say? That is an amount of rupees 51,64,800
Yes.
to the petitioner within a period of 3 months without fail. Okay, so this is disposed of. This is gone. What about writ appeal?
Writ
What about the
petition.
petition?
My lord, we've sent all my report, my lord. So
Same facts I will write it
Yes,
there
same
and in view
facts.
of the. Yes, Miss Venishame?
Yes, regarding the writ petition, Your Lordship, as I have already mentioned, this writ petition cannot be entertained at the moment because this is the same course of action. And Your Lordship, another
In
thing.
view of the order passed in the contempt petition,
Yes,
this
and-
writ petition is closed and disposed of.
And Your Lordship,
My lord.
another thing. The contempt petition, that cannot be dismissed at
That
this
cannot
moment.
be closed at this
So
moment,
if that-
unless payment is made, my lord. So maybe
the
it may
next
be
date will be
closed.
fixed
Yes.
No,
after
if payment
2
is not
months.
paid, you again file a contempt application.
No,
But
my
then
lord.
writ petition cannot be kept alive.
No, my lord, the pending payment, my lord, if they can pay, then we can close it. If that may be kindly reflected, my lord, because we have been waiting for since 2022. Now, what's the point of filing again if they do not comply within 3 months, my lord? So it may be kindly reflected on the order that the contempt may be closed after payment of this.
No, that we cannot do. This is closed only. It is disposed
Only
of.
my lord, liberty may be given to file, my lord, if not complied, my lord. That will
No, this
Your
is a
Lordship-
court's order. Why do you, actually there are so many contempt matters, people have lost hope.
Yes, we'll pay.
No, it's not required. It's okay.
Because
I've
everything-
directed to pay them, pay it. If they do not pay, you have to file application. How can I keep it pending?
My lord, my lordship, everything is, it is reflected, my lord. So we
Okay,
have
and
to pay.
then a writ petition in view of the order passed in the, right, in writ petition. In view of the order passed in the contempt application, this writ petition is closed and disposed of.
Highly okay.
Okay.
My lord, we'll pay, my lord, this time we'll pay.
This time you please pay. You
We'll
should
pay, my
not
lord.
be,
No, I'm assured my
Yes.
sister also, my lord.
you please pay because everything is done, all
Yes,
verification.
ma'am.
You cannot turn.
Yes, ma'am, yes, ma'am. The railway is, my lord, it is their duty, my lord.
Ah,
Only
they-
their part, my lord, there's sometime, my lord, otherwise directly, if they, if court order is, my lord, they are now, they will pay. my lord.
Yes, court order, and they have been paying so much. Why this poor man should be kept?
When matter was listed again, my lord, I thought this court will pass this order like this, my lord.
Oh, no. I went and deliberated with myself, and I thought I had heard the matter for so long.
yes.
My anger should not be actually there.
No,
So I don't know. I'll dispose it of. Okay. Chalo.
Highly
No other
Much
matters, right?
obliged.
Highly appreciated.
Thank you.
Now we can rest.